So that act, whether intentional or not, that causes another harm is what we will be discussing. And we talked about the characteristics of torts, that it's a private wrong. And we talked about the person who commits a tort is the tortfeasor or the wrongdoer. The litigation for tort is compoundable. And this in essence means that today if you file a suit, tomorrow you can withdraw the suit. We also talk about tort being a species of a civil wrong, and the remedy is unliquidated damages. Liquidated damages is where there is a specified amount of compensation. So party A and party B, whoever is found to be on the wrong, you pay, you've already agreed on what the compensation is. So unliquidated, which is a characteristic of torts, it's unspecified. When you're taken to court and the matters are raised and you are found to be liable, it's at the discretion of the court and the nature of the case to determine what the wrongdoer will pay. We talked about the nature of a tort, that of a breach of duty primarily fixed by the law. And you as the plaintiff, you who is taking your neighbor to court, you must prove that you have suffered harm and there has been a violation of your legal rights. We will see about trespass on the person, trespass on goods, on land. So you can't just say you are wronged. You need to prove that the actions of another individual caused you harm and you violated someone else's legal rights. But some are actionable without proof to injury. For example, as we've said, trespass to land. When you come into I have fenced my land, I am grazing my cattle there, then I find you have cut the fence, you have gained access. There may not be damages, or you have jumped over the fence. I don't need to prove any injury. That action itself is evidence enough. So there are two principles in tort: damnum sine injuria, that is the harm without a legal injury, and this is causing damage without the violation of a legal right. And we have the case of the Mughal Steamship Company versus McGregory, Gow and Company, where a number of steamship companies conspired and drove another sea carrier out of business by offering lesser rates. Even though the plaintiff was financially injured, the House of Lords ruled that other companies were entitled to indulge in such competitive practices and therefore no cause of action. So what happened? For this, damage has been caused, but there's no violation of any legal right. When you have a building, let's say these buildings in OBCBD that have stalls, and these stalls sell phones. If stall A decides to lower the prices of their phones and therefore more customers, you in stall B cannot take stall A to court and say that you are suffering losses of sales. That is true. But stall A has done nothing to cause you to suffer. Their lowering of prices has not breached on any right of yours. You can as well lower the price. You can as well do other business practices that will make more customers attracted to you. So that is what we mean by damnum sine injuria. There is harm without legal injury. The lowering of prices is not illegal. It's a business practice. We also have injuria sine damnum, where one suffers a violation of his legal rights without actual injury or damages. In this instance, a person is entitled to a remedy. In Ashby versus White, the defendant, a returning officer at a voting booth, wrongfully refused to register a duly tendered vote of the plaintiff, who was a qualified voter. The candidate for whom the vote was sought to be tendered was elected, so no loss was suffered by the plaintiff for rejection of his vote. But the court held that the violation of the plaintiff's right was an injury to him for which he must have a remedy without proof of actual damage. You see, whether or not my candidate won, the fact that I did not get a chance to vote for this candidate because the fact that my vote was not counted means I suffered a harm. So my candidate winning does not mean everything is sorted. No. My vote should have been counted. And the person who caused me that harm, I can sue and they will be liable for damages. So what do we use to determine this tort? Which principles do we use? Because it's necessary to establish some fault on the part of the wrongdoer. You cannot claim someone is liable without establishing what this person did or failed to do that caused you harm. So number one is the intention. Where one does a wrongful act intending the consequences. You thought out and you decided to not register that vote so that this person is less one vote, knowing that that one vote could swing. So what was your intention in not registering that cast vote? Number two is the element of recklessness. You don't care what happens. So what if I don't register that vote? See, it's only one. It's just one vote. What is the big deal? You're being reckless. The big deal is that that vote can swing either way. Number three is the element of negligence. Doing something that a reasonable person would not do, or meeting an action that a reasonable person would do. So when you go and refuse to register these votes, and you do not follow up and ensure that this omission of registering is sorted out, you're negligent. You had a job to do, and you did not do it to the best of your abilities. There's no justification for you to not register that vote. So for us to determine tort, once we determine that fault principle, that the wrongdoer did something before he's made liable. If we're not able to determine what the wrongdoer did, then there can be no action.